You ever send a homeowner on their way and just say, hey, there's a few cards that you can play on your own?
Oh, yeah. Self-help. Internally, we call it a roadmap because what we've done is we've built a roadmap for the client to take. I shouldn't say client. I should say, potential client,
Yes.
someone that we consulted with.
Yeah.
The homeowner, we say, try this first. Run this play.
Yeah.
And, sometimes they do it very efficiently, which in my book is a win.
Yeah.
If you don't have to hire a lawyer, that's awesome. I'm Luke Carlson, and for almost 2 decades, my law firm, Ellis Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of Ellis Carlson Law. Welcome back to the show. Today, as usual, I have Marty, our producer.
Hello there. Good to be back. Thanks for having me.
Thanks for joining us. And today, I love today's topic. You engineered this, so I typically let you take the lead but I like it because it's so relevant. These are questions, well, you lay the foundation.
Okay, so last episode, we did the AMA episode, which was a ton of fun.
That was fun.
Just because there were so many good questions. However, there's quite a few questions that we couldn't get to just because of the time restriction. We would have been here 12 hours.
We would still be here.
We would still be here a week later. So the idea was a lot of people had the same questions, and we got a lot of frequently asked questions. I know you get almost in all of your consultations. So I thought this would be a great continuation of the AMA. But for the questions that people didn't ask, there's a lot of questions, the frequently asked questions that still need to get answered. So I thought we would extend that. We got 9 questions that I know you receive frequently, and I did a couple searches here. So we're just going to kind of make that continuation on in this episode of the frequently asked questions that you receive in consults or receive as an HOA attorney that the AMA might not have asked. Yeah,
no, I love it. And I guess from my perspective, the preference here is to respond by way of my law firm, or do you want a more general response? What would be the most helpful to the market?
I mean, I think people are looking for generalities, and I think there's a couple questions here that are specific to the firm. I think we can just kind of
maybe I can run them both ways.
Yeah,
I like that.
Okay, let's dive in.
All right.
Number 1, why do HOAs have so much power?
Yeah, I was looking at this earlier, trying to think of how I'd like to respond or what the best response is. I think in this, there's an assumption built. So the assumption always is HOAs have all the power. And I would say that's generally true when the power goes unchecked. And I've said that before.
Yeah.
If you have unchecked power and no one's standing up to a bad HOA, no one's enforcing their rights, well, they have all the power because no one's stopping them.
Yeah, it's like it's people looting and stealing, but there's no consequence.
Correct.
So what's the point of the law?
There's no enforcement.
Exactly.
And, to look at this in a different light, HOAs have power, yes. Homeowners have power, absolutely.
Yes.
They both sides have power. So it's leveraging that power. And, when you have a bad HOA, standing up for yourself, standing up for your rights as a homeowner.
Yeah.
In doing so, it changes the paradigm. It changes the way you see an HOA. Because HOAs do not have endless power. They don't. They are restricted, and the homeowner has, they have a tremendous amount of rights, both by way of state law, by way of the governing documents, that when enforced correctly, you can push back.
Yeah, so many people just say they have so much power, and they have some power, but it's funny because I think in well-run HOAs, and you just abide by the CC&Rs. I think would you say that most CC&Rs are fairly fair? I mean, let you live your life to a reasonable extent, and to the extent that they don't, they kind of knew of this ahead of time what they were signing up for. Not to point blame.
Right, but when CC&Rs, when governing documents are not weaponized
Yeah.
or used wrongfully. They tend to be even keeled. The biggest problem that I have typically with governing documents is how poorly they're drafted. There's a lot of ambiguity.
Sure.
Ambiguity causes a lot of problems.
Yeah.
So, and we're 100% homeowner focused. We always represent the homeowners.
Yes.
We never take the side, or we never represent HOAs. We don't go to the dark side. But, the biggest piece of advice for associations is to have up-to-date CC&Rs that are very well drafted. There are attorneys who represent associations that can actually draft very well. And I've seen these governing documents that are crystal clear. And when you have that situation where you have crystal clear documents, things go better. The problem is when you have ambiguities. I see a lot of disputes arise simply because of poorly drafted governing documents.
Do you ever get in a situation where the governing documents are updated and then it puts a bunch of homeowners out of compliance with certain rules and regulations?
Yeah, I mean, not to get too technical, but there are notions of certain things being grandfathered in. So there's this, for example, if you have a swimming pool and the CC&Rs all of a sudden prohibit swimming pools, it's unlikely you're going to be in a situation where you have to rip out your swimming pool.
Sure.
It's going to be grandfathered in.
Okay, makes sense.
So, but again, a good HOA attorney is going to think about impact and educating a community. If there are changes, how are those going to be handled internally?
Yeah.
So
to wrap up, why do HOAs have so much power? They don't have as much power. They do have power, not as much as you typically think. And if the power goes unchecked, then you have given up all the power.
Correct. I think the misconception there is they have all the power.
Yeah.
They don't have all the power.
Yeah.
Homeowners have a tremendous amount of power. They just have to understand how to unlock that power.
Yeah.
Right.
Oh, which is a really good segment to the second question, which is, how do I win a fight against my HOA?
So this is a fun way of articulating, what do I do? How do I prevail? How do I enforce my rights against an HOA successfully? So there's different methodologies, and we've discussed them before. Sometimes you're going to get a victory by a simple negotiation. You don't even bring a lawyer in. We discussed IDR, which is informal dispute resolution.
Yep.
We discussed steps that are even a precursor to IDR, where you just have a one-on-one with the board.
Yeah.
And, if the board, again, is operating in good faith, where there's a reasonable set of individuals sitting at the board, you might get a win just through conversation.
Yeah.
Just through simple negotiation.
Yeah.
Now, the other side of that coin is you may have to get a win through protracted litigation. That's the extreme version, right? And again, it all goes to enforcing your rights. But, assuming that the association has violated your rights in some way and, you have the evidence to support that, it's then just how to enforce.
Yeah.
And it can start with simple negotiations. It can escalate to informal dispute resolution. If that doesn't work, it might be alternative dispute resolution, which is a pre-litigation step in California.
Can we roll it back just a little bit in terms of kind of layman's, like we went through our 6 steps. We have a whole episode on the 6 steps. But if we want to roll that back just slightly, it would be if you've got an issue, document everything. Would be, you want to go through these just real briefly?
I think that's appropriate. So let's say there is a dispute.
Yeah.
And your rights are being violated. First things first, get the documentation in order.
Yeah.
Mission critical. And when I talk about documents, it depends on the nature of the dispute, but it could be emails, it could be photographs, it could be video, it could be all of the above. It could be an expert report, an expert coming in validating your position.
Yeah.
Especially with water intrusion issues.
Yeah.
Having a good report saying, hey, the water intrusion is coming from a common area. That's documentation.
Yes. And
get it organized. And that, I would say, is a great starting point.
Yeah. And then after that, bringing it to, review your CC&Rs would be the second step.
The second step is, or concurrent with the first step, is to have a strong understanding of the governing documents.
Yeah.
Understand the provisions, look at them. I know it might seem daunting, if you're sitting in front of a bunch of governing documents. But, I guess to make them a little bit user-friendly and assuming that they're not digitized, right? You can do a Control F.
Yeah, Control F that baby.
If you have a PDF and they're optimized, then that's an easy way to navigate. But assuming it's analog, it's just paper, use the index.
Yeah.
You don't have to start on page 1 and read it from top to bottom.
Sure.
There are ways to access these documents that are a little bit more efficient.
Yeah.
So, for example, if you're dealing with a common area issue, well, look in the common area section. If it's dealing with a maintenance, who's responsible for maintaining a certain area, there should be a maintenance provision. So look at the provisions. I'm not saying it's going to be quick and easy, but I think the task of reviewing your documents is a little bit more user-friendly once you start to understand, okay, these aren't terribly or horrifically challenging to get into,
Sure.
especially if you start with the index.
Sure.
So
yeah, makes sense. Okay, then after that, it was bring on the expert as well, which we kind of brought into the fold, and then it was before IDR. It's just have informal conversations with a board member that's willing to talk to you and try to do it with an elevated vocabulary. To make sure that you're well educated on the CC&Rs and the laws, so you can go at it intelligently and without emotion. Yeah,
I harp on that a lot. It's a common theme in what I say to most homeowners is when you can present the information clinically, and that's hard. Often you're very upset, you're mad, you have venom that you want to spit over the HOA, and probably for good reason. I'm not discounting that at all.
We talk about this every episode, but it is your home. I mean, this is supposed to be the reprieve. This is supposed to be where you get, this is supposed to be your safe space, and it's now being encroached upon by a bad, poorly ran HOA. And it just, you come home to a nightmare. And it could be multiple years. So I could see how it'd be very difficult to get that emotion out of it.
And it can be a challenge, but if you stick to the facts, and you stick to the CC&Rs, the governing documents, and you present as best as you can a clinical articulation of the problem, of the dispute. Yeah. That goes a long way. Yeah. And to elevate your language or vocabulary, I think that's important.
It really shows that you mean business, you know what you're talking about, and they should probably take you a bit more seriously.
Exactly. I think it's very common, what I've seen over the last decade, now much longer than a decade, is where you have clients or homeowners who have a really good case, but they're so frustrated. So whenever they approach the board, they're just angry. They're saying, hey, you guys are horrible. They're using very emotionally charged language. And the problem with that is the real dispute gets buried in that. And the board pushes back because they just hear a bunch of yelling and name calling, as opposed to something a little bit more concrete. And what I mean by that is, instead of saying, HOA, you're a dumpster fire, you're hellish, you're making my life a nightmare. What you could say, and I think it's better, the better approach, the more sophisticated approach, is you say you are violating this provision of the CC&Rs. And by the way, it's caused damage. And this damage has been articulated in my expert report. That actually creates a totally different conversation. It's an elevated conversation at that point. And that's important.
Yeah. Next one would be if you get nowhere and they're ghosting you and you're not unable to talk to anybody, they're ignoring your emails. In California, under the Davis-Sterling Act, initiate IDR.
Yeah, I like IDR in theory. Now, I often say if your board is unresponsive and there hasn't really been that much communication and you're not certain that they're ignoring you intentionally, there might be a variety of reasons. The demand for IDR under the Davis-Sterling Act or the demand for informal dispute resolution under the Davis-Sterling Act is not a bad strategy. Yeah. And really what it is it's a demand where you're saying to the board, I have certain issues with the board. Yeah. Here's my dispute. You outline it. I would love to sit face-to-face or over Zoom nowadays and discuss it with you. Yeah. Now, the theory or the spirit or the public policy is that homeowner and board are supposed to come together, sit down in good faith, and have a conversation. And what that should do, in theory, is negate the need for lawyers to get involved or the court system or mediators. Yeah. And they work it out as neighbors. Yeah. The problem with IDR is when you have a bad HOA, when you have a bad board and you already know it, and you make the demand for IDR, and the board will say, okay, yeah, we'll sit down with you. And the board approaches it with bad faith or in bad faith. And then it's just a yelling match. And I don't always recommend a homeowner expose themselves to that situation. And,
is it just because no sense in putting yourself through the aggravation?
Why? There's other methodologies. If you know it's not going to go anywhere, you know the board's going to show up in bad faith. Let's say you have a tyrant on the board, or you have someone with an axe to grind against you, and you've extended olive branches and they've been nothing but bombastic. I don't know if that's the appropriate step.
Would it not, though, for optics' sake, if you were to get to the point of you have to bring in a lawyer or a mediator at that point, or it gets even further to a judge, that it shows you've acted in good faith by trying to get in front of them?
Well, often when I'm saying that IDR isn't the best strategy, you might already have a long paper trail.
I see.
You may already have 20 emails back and forth of them being bombastic towards you. And
so you already know that you show a very good evidence that they've acted in bad faith since the beginning.
And that's why I said, if you don't really have a good read on the other side, or there isn't that long history of bad faith relations with an HOA, IDR tends to be a good opening move. Now, sure, you could always use it strategically, knowing that they're going to operate in bad faith.
Yeah.
And use that. You still show up in good faith. Maybe they changed their mind, or they woke up on the right side of the bed, which is unlikely. But sure, you could always subject yourself to that just to shore up your position.
Yeah.
You could.
So the last one, and then we'll move on to the thing, is if all else fails, we've gone through all the steps, you're not getting anywhere, it's probably time to seek some legal advice.
I think so.
Yeah.
You always got to look at what are you looking to gain?
Sure.
Because you have to understand, most attorneys who practice in this field often run it on an hourly basis.
Right.
And so you have to look at the economics.
Yeah.
I think that's important. And, some maybe attorneys try to hide that reality, but I think two sides need to add up. The legal side has to certainly add up to prosecute, but you always have to look at the economics. What is it going to cost to enforce? Is it worth it? And do the two pencil?
Sure.
So, the best starting point is often through the consultation. It's not immediate retaining a lawyer. My recommendation is try to spend an hour or so with a lawyer and have them look at the situation, have them look at the dispute and analyze it, and, analyze it in a way where you're informed and empowered.
Sure.
Through that process. But yes, to your point, at that point, I think bringing in a legal professional makes sense on some level, even if it's just consulting.
Perfect. All right. A lot of content already, and we're only at number 3.
Wow. Okay.
I know. Can you sue an HOA? This will be the fast one for you.
So let me analyze it in California, under California.
Sure.
Yeah, you can sue an HOA. You can. Now, there's certain pre-litigation steps that are often required. And those
interesting.
Pre-litigation steps, I'm speaking broadly here, okay? But generally, before you fire off a lawsuit or file a lawsuit against an HOA, you're going to want to go through the ADR process, which
is that... Yeah, well, explain it first, and I'll ask the question.
It exists in the Davis-Sterling Act. It stands for Alternative Dispute Resolution.
Yeah.
And what it is, it's a precursor that you go through this process first, and you do it, well, one, to actually settle, so you don't have to file a lawsuit.
Yeah.
But one of the big reasons you do it is to preserve your right to attorney's fees.
Oh, interesting.
Because with certain cases, if you don't go through ADR, right, you may jeopardize your ability to procure attorney's fees upon prevailing in a lawsuit.
That is fascinating, and I did not know. I mean, see, I still learn something new every episode.
Yeah, it's interesting. Sometimes, we've entered into cases where a real estate attorney has started the case. They filed a lawsuit against the association. We look at it, and the case is actually articulated correctly. It's pled correctly. We talk about pleadings, but the complaint was proper in form. The issue is they never went through ADR. They didn't do the ADR process. So on occasion, what we'll have to do if we're retained, we actually have to dismiss the lawsuit and go back to the starting point of firing off an ADR demand. And we do that to preserve the client's right to attorney's fees.
Interesting.
Because the last thing you want to do is prevail, right? You go through this huge process of litigation, which is, it's a journey, to put it mildly.
Yeah.
And you prevail.
Yeah.
And then after you prevail, you file what's called a motion for attorney's fees, and the judge denies it because you never did ADR. You never attempted ADR. Now,
is that in the law, or is just it's on a case by case basis, and the judge is?
Well, it's built into the Davis-Sterling Act. To procure attorney's fees. Often, now there's certain circumstances where it doesn't fit nicely into this box. But
and again, just to reiterate, this is California.
This is California.
Yeah.
But very generally speaking, you have to go through the ADR process first in order to preserve your right to attorney's fees.
Does that require always trying to meet with trying to get a mediator involved or an arbitrator? What is this? Just the 40,000 foot 30-second view.
So ADR is really a fancy way of saying mediation. So you're looking to get a mediator involved.
Okay.
Now, mediation is different than arbitration.
Sure.
Because you look at arbitration. Arbitration is really litigation. I mean, that is an arbitrator steps in. It could be one, it could be three, it could be a panel. And the arbitrator or arbitrators, they're rendering an opinion. They're actually making a decision.
And it's a legally binding decision.
Well, I don't want to get too technical.
Okay.
There's binding arbitration and there's non-binding arbitration.
Okay.
But going over into the binding arbitration box, yes, if you prevail in binding arbitration, what happens is you take that arbitration award, okay?
Yeah.
And then you take it to the court, and the court stamps it, and now it becomes enforceable.
Ah, interesting.
So I know we're a little bit off topic.
I know.
We're down a rabbit hole, but
the people,
ADR
the people want to know the questions,
Yeah.
and I know it's a little deep, but
it's
there
a good
you go.
one. But mediation is non-binding. The mediator is there to facilitate a resolution.
Sure.
And what does that mean? Well, here's what it means. You show up at mediation, and typically, you're in one room with your lawyer, the other side's in their room with their lawyer, and a retired judge or an attorney who's a mediator is bouncing back and forth trying to get resolution. But if the mediator comes into your room and says, hey, you have a phenomenal case, the law is on your side, the facts are on your side, I need to get the other side. I'm going to try to persuade them or influence them. In theory, the mediator could go to the other room and the other side can say, kick rocks, we're not going to settle. The mediator really can't do anything to stop that outcome.
Sure.
The mediator cannot compel nor force the other side to settle.
So if you do end up in a situation where you don't come to a resolution with a mediator, then then it's lawsuit, and you can sue for attorney's fees because you've gone through that process. Generally
yes.
speaking,
generally yes. And if the mediation does not resolve, and there's no winning or losing in mediation. People say that quite frequently. They're like, I want to win the mediation.
Yeah,
it's not that. It's either you settle, you reached a compromise or a resolution, or you didn't.
Yeah.
And, as I see it, there's typically three outcomes for a mediation. One, you get everything that you want because the association doesn't want to get sued. Often they know if it doesn't settle, the next step is a lawsuit. So
they're incentivized to get this thing
It
cleared
behooves
out.
them. It behooves them to settle. It doesn't settle at all, and there's no resolution, or it's somewhere in the middle. Generally, three outcomes of the mediation. It's never a win or lose, although I guess I could see why people would say, I won the mediation because I got everything I want.
Sure.
But it wasn't really a win in the sense that no one said that you were the victor. You were the prevailing party.
Sure.
In arbitration, yeah, you do win, you do lose.
Yeah.
In court, you win or lose.
Yeah.
Right? So there's, but to use the proper, I guess, vocabulary in the mediation, it's always, did it settle? Did you get what you wanted in terms of negotiation and compromise?
How many, in terms of the cases that you've seen, I would assume quite a bit go through ADR, if not all of them.
The majority go through the ADR process, although there are times where there is a different strategy. Maybe it's economic reasons, maybe it's just efficiency reasons, where we utilize a demand letter to start. It is as almost a precursor before we go into the ADR modality.
Yeah. So I don't know, just getting just some background, how many, it's impossible to say, but in generally speaking, are most heading that direction of cases that you see? You see it, and typically you say in a consultation, this looks like it's pretty cut and dry, decent case. Is it always going to go to ADR? And how many times does it settle? Is it majority of cases settle there? Or is it like 25% end up in litigation?
I would say a good majority settle. But because I get asked that question a lot.
I would assume that's probably the number one. Do I have a case? I mean, that's actually a question, but we'll get to that.
No, the question that I get is, how successful are you? And it's sort of a trick question, because even if a lawyer had a 100% success rate and knocked it out of the park every single time, that does not mean that they're going to be successful. They could fail miserably. And I say that because let's use the ADR context.
Yeah.
You're going through the mediation process, and your case is perfect from a factual perspective, an evidence perspective, a legal perspective. The mediator high fives you when you get there, and they're like, "Oh my God, what a wonderful case! I'm sorry this is happening to you." You have a human element on the other side, and that human element is the opposing counsel and or the board members.
Yeah.
And they could say, "Yes, I see their argument, but go kick rocks, sue us." Doesn't matter how well that argument has been presented. It doesn't matter that the mediator was absolutely persuaded by your argument. You have the human element and you have the free radical other side, opposition.
Yeah.
So even if you had a 100% success rate for 30 years, you could still fail miserably.
It's still getting at bat, and you might strike out that time.
Correct.
Yeah.
But it's nothing that you're necessarily doing wrong. It's 100% outside of the control of your advocate. It's outside of the control of what you're doing. It's outside of the control of the mediator. So that's how I respond to that question.
Very good. All right. Can I just send a demand letter?
Sometimes yes, and sometimes it's a waste of time. And
it's when it's just so contentious, it's just not going to go anywhere.
Yeah, I mean, we get situations where I think a demand letter is a great strategy. I say, let's test these waters. Let's fire off something. Let's get a legal letterhead. Let's make the argument. And what happens internally, what might happen is that letter might get kicked up the chain of command to the lawyer. And assuming the attorney is reasonable, the attorney might see it and say, hey, you know what? We don't want to have a problem here. Let's try to just resolve this very quickly. Now, that strategy, when it works very well. But the problem with the demand letter is sometimes you'll fire it off, and the opposition will get it and say, hey, they'll call you and they'll say, hey, I got your demand letter. You raise a bunch of good points. Let's negotiate this. And all of a sudden, your attorney and the opposition, the opposing counsel, they're in this huge back and forth that lasts a very long time. And, you're paying a lot of money for that, these negotiations.
Sure. Yeah.
And, 6 months down the road, you spend 30, 40 grand, and your attorney calls you and says, yeah, the opposition says, go kick rocks. And what happened there is your attorney was outfoxed by the opposing counsel. The opposing counsel had no sort of intention nor desire to negotiate really in good faith, but they were stringing you along. And that's why there was so much
strategy. What is their end game then?
Well, the end game, I think, is two things. One, to milk you for money, because they know you're paying for this. Two, to frustrate you, right? You're kicking the can. So if you can sort of tire out the opposition.
I see.
Then think of it this way. Now you're the homeowner. You just hired your lawyer. You're 6 months down the road, and you're in no way, shape, or form are you in a better position, right? And so now the next step would be ADR. And so now you got to go back to the ADR process. Now, if you would have started with the ADR process, you would have been on a much quicker time frame, and it wouldn't have just been a back and forth between your lawyer and their lawyer.
The opposition, yeah.
You would have a third-party neutral in the mix.
Yep.
And they also know if it failed, your next step is likely going to be litigation because you're teeing it up for a lawsuit. In the demand letter strategy, your next step is starting at the very beginning again to go through ADR. So the consequence isn't as big. If it doesn't resolve itself via a demand letter or informal negotiations, likelihood you're still not going to jump into a lawsuit, right? likelihood is you're going to start with the ADR process. You almost have to reboot the system to start there. But if you start with ADR, you're sort of you're hardlining the attack.
Yeah.
So yes, you can start with the demand letter. It's a very specific fact pattern or situation or relationship with the HOA where a demand letter is justified.
So what you do in the consultation, and maybe to the point of retention, is kind of build a strategy in your mind, understand who the players are on that side, and say, would the strategy work? And then you probably know, doing this for, I think it was 17 years now, know when to pull the plug and just say, these guys are towing us along. We need to move to the next step. So kind of lay those things out.
Yeah. Even with the demand letter strategy, it's wise to be very mindful who the opposition is and where it's going. And there's certain signs that you'll be able to tell if the opposition is just kicking the can down the road. And if it is, our recommendation is switch, be dynamic. Let's make a different decision and not go down this rabbit hole of endless negotiations that are going nowhere.
Sure.
You're just burning money at that point.
Yeah.
That to me makes no sense.
Yeah.
So
that's a great long answer that we had.
That was a long answer.
But that's, I've seen this question come up frequently.
It's a valid question, and we get asked it quite frequently. And, again, it depends on a lot of factors.
Do you see the same attorneys on the other side pretty frequently?
We see the same law firms frequently.
Yeah, that's what I.
Yeah.
So, we know these guys, and vice versa.
Yeah, and I always say it. There's some really amazing ones that I respect.
Yeah,
and there's ones that I don't respect.
Yeah.
So
bonus. That was your bonus question. That will be the 10th one. Okay. How much does it cost? And can you sue for attorney's fees?
Well, like I said, so long as you follow the proper formalities, attorney's fees become part of your damage claim. How much does it cost? So I think you got to cut that down a little bit and put it into buckets. So there's different strategies, right? The demand letter is going to be cheaper than full-blown litigation.
Yeah.
A demand letter, if it works, it can be remarkably efficient and economic.
Yeah.
We're talking a couple grand.
Yeah.
You get a good lawyer, they write the demand, they fire it to the other side. The opposing counsel sees it and they say, oh, I get it.
Yeah.
Let me negotiate, and it's resolved.
Yeah.
Wonderful outcome.
Yeah.
ADR can be pretty successful too. You fire off an ADR demand and the opposing counsel says, you know what, we don't even need to go to mediation. Let's just talk about this. Let's get it resolved. Wonderful. That's a very economic way to approach these things. The flip side of that, though, is it becomes a protracted, dispute. Even like I said, the demand letter, you send a demand letter and there's a huge back and forth. Those can get expensive.
Sure.
ADR can get expensive if it goes all the way to mediation. And of course, litigation can be very expensive. So, I guess how much could it cost? On the best case scenario, you're looking at a couple grand.
Yep.
Up to, you're in the six figures. So there's a huge spread on that.
Yeah.
Again, though, if you're prosecuting, you're likely going after attorney's fees.
How, in your experience, how often do people prevail with attorney's fees? Assuming they prevail. Let's just assume that they prevail. How often are they awarded attorney's fees? How often are they getting those back?
If they prevail and they're entitled to attorney's fees, it's going to be a motion for attorney's fees.
Yeah.
And, courts have the discretion to award 100% or give it a haircut. And you see all different results. It's all over the board. It would be impossible to say with any precision.
Yeah. It's going to be a question that they're. Do you get that question a lot in your consults? Like, what are the chances? If I'm sitting with you and I say, I'm trying to make an economic decision on this, I'm going to want to know what my odds are. You know what I mean? Both in the case that I prevail and the odds of getting my attorney's fees back. So I can make that. I'm willing to roll the dice.
And I'm going to give you a weird response to this.
Okay.
If you have an attorney giving you odds, you may want to call a different lawyer. Because it's an unpredictable ecosystem that we work in.
Yeah.
There's so many variables.
Yeah.
Judges get things wrong, dead wrong. How are we going to know? Now, granted, there's appeals and there's certain things that you can do. But again, it's not scientific. It's not math. There's a human element that makes it so unpredictable. Now, our job as lawyers, and I think an honest lawyer will say this, is that their job is advocate.
Yeah.
They are presenting the facts. They're presenting the law. They are trying to influence another side to agree. But because you have a human element, there's a lot of other motivations. Even the court system can get things wrong just because they're understaffed, for example.
Sure.
You could have the best advocate and lawyer on the planet, but if you have an understaffed bench or someone who just didn't read the papers, there's a number of reasons why they get it wrong.
Yeah.
That was outside of everyone's control. So that's why I say any sort of odds, trying to give odds or trying to give a percentage, that scares me because I know for a fact that you can't do that.
Yeah.
Short of a crystal ball. If you had a crystal ball, fine. Short of that, it's an unknown space.
That said, you've been doing it for 17 years. If you were prevailing, then you wouldn't be in business
We've been
anymore.
successful. We've been successful. We've done tremendous good for homeowners throughout California and Florida. We've gotten tremendous results. We've seen real justice.
Yeah.
But I always say, even putting that and looking at that, every day is new, every case is new, and the people on the other side are new.
Yeah.
So I can't say that because we've been successful historically, you call us, you're going to be successful.
Sure.
And I know that's brutally honest.
Yeah, it is.
But I prefer to be brutally honest.
All right. Let's move on to the next one. Do you work on contingency?
So this firm, we're an hourly firm.
Yeah.
We don't take on contingency cases, and it's really a business model. Most firms in this space are hourly. It's very common. Now, contingency work you typically find in the PI space, personal injury.
Yep.
Different forms of professional malpractice is contingency. I guess the question is, why don't we work on contingency? A lot of the disputes don't really lend themselves to contingency work. So, for example, what we're seeking is specific performance.
Sure.
We're looking for an association to stop something or to do something. It's not necessarily, you don't monetize it, or it's property damage, right?
Yeah.
Let's say we have a case where, our client has $500,000 in property damage, and we're taking on a 40% contingency or 50% contingency. They get the $500,000, but we claw out $250,000.
Yeah.
So now they still don't have enough money to
finish the job.
Correct.
Yeah.
So I think it's very rare to find a lawyer in this space to work on contingency because that business model really doesn't work.
Yeah, and much like you said, sometimes there's no monetary value. You just
We're not
want them
seeking
to they just want to stop what you're doing so we can go back to. And how do you work on contingency on that?
Correct. Now, what we do assert though is, hey, here's a specific performance claim. We want the association to do something.
Yes.
And by the way, it costs X in attorney's fees because you guys violated the CC&Rs.
Yes.
So now we want both.
Yep.
And that's how we sort of go about making our clients whole.
Got it.
So
yep, makes sense.
It's a fair question though.
Oh, the dreaded do I have a case? We kind of covered this, but we should just touch on it briefly.
Yeah, I like do I have a case questions. When someone says, do I have a case, I think what they're really saying is, am I going to win? Maybe
they wanted. Okay, I'll speak from experience. I would probe that just to think, do I have a shot at winning on this? I'm trying to figure out the odds in my head.
Right.
It's on the economics. Is this going to be worth it for me? Should I continue to pursue this and pay you to take care of it?
So the proper analysis looks like this. You got to look at the facts. What are the facts of the case? What does the law say? What can we prove up? What's favorable? What's unfavorable? And running that analysis, sometimes clients do not have, or potential clients, I should say, or clients that come in and consult, they have no case. They don't. Because of some reason. Maybe it's a statute of limitations issue.
Oh, sure.
Maybe they waited too long. They come in and they say, hey, 5 years ago this happened.
Are you just brutally honest with them too?
I'm very...
You're straightforward.
I don't sugarcoat things.
Yeah.
It's not my nature. And I don't think it's right to sugarcoat.
I don't think it's necessarily helpful.
I don't think it's helpful at all. I'm a realist, right? And that's how I approach the law.
Yeah.
And so when I see a case which has nothing, I tell them that if you pursue this case, you're going to go off a cliff. Now, there's other cases where I see great facts, I see great law, and I would say not so much the saying, do I have a case, is sort of how do I say this? It's so broad. It's such a loose way of saying something. I think the better way of saying it is, do I have viable claims? Do I have a right to enforce? Have my rights been violated, and can I respond? I mean, now we're speaking with more precision than do I have a case?
Yeah, but that's the layman's terms. People
Fair
just
enough.
want to know
Yeah.
that did I? Yeah, I guess it's
Have
not
my
just
rights been violated?
have my rights been violated?
And can I do something about it?
Exactly.
Now, the other part of this, which doesn't cover this, is even if you do have a case, I guess, meaning the law and the facts are good,
Yeah.
right? They're enforceable. Economically doesn't make sense, because that's the other part of the equation
Yes.
that you have to look at.
Yes.
Because you can see a wonderful case. You know, your rights have clearly been violated, and there is something a lawyer can do. But by the way, looking at the economic side of things, it doesn't make economic sense to move forward.
That makes sense.
In other words, you don't spend, $100,000 going after $100,000.
Yeah.
Right?
Yep.
So you got to look at both sides of the coin. And that's how I responded, do I have a case? That's the analysis. It's a legal analysis, and it's also an economic analysis.
When you're in the consultation, just being on the side and getting into your head, when you're looking at something, you look at it right away and said, "Oh, this one's clear as day. This is juicy. We can help these guys." Do you kind of take that internally? And being brutally honest, I'm assuming that's brought back to them in some way or another, probably more tactfully than.
Well, the consultation, often you're looking for articulating causes of action. That's
Okay.
what I'm looking for. What does the negligence claim look like? Do we have a breach of fiduciary? Do we have a breach of the CC&Rs? And I'm looking for enough information where I say, you know what, this is looking viable. There's viability in the breach of contract claim. There's viability in breach of fiduciary. So consultation-wise, that's sort of step one. And it's also, though, identifying, okay, you have these causes of action. What is the proper methodology to enforce?
Yeah.
How do you enforce?
Yes.
And once you flesh this out, then it is road mapping it, saying, okay, these are the steps we're going to take. This is how we're going to go on the offensive. But after retention, there's another due diligence phase that happens. And we really kind of dive in a little bit deeper just to make sure that what happened at the consultation is viable and it's going to work on the other side.
Do you have multiple lawyers then that look at that? So there's you did the consult, and then they come out as a team afterward, and do multiple lawyers usually look at it at that, and they kind of round table it to determine, oh, did we miss something here, or put together a more robust strategy?
Normally we run a case with two attorneys.
Okay.
You have a lead and you have support.
Okay.
And between the two of them, they work on the due diligence, the analysis. There's a lot of fact gathering that happens even after the consultation.
Yeah.
But generally, if we're recommending retention, at that point, we feel fairly confident about the case. And
interesting.
there's situations though where we've been retained. I felt really good. I did the consult, everything checked out, and then they gave us a data dump subsequent to, and they may have signed something that they didn't realize they signed, which could be very problematic.
I see.
So at that point, you're almost running, this strategy where it's like, hey, this was the play. This changed everything.
That makes sense.
And you have to re-strategize based upon that change. Now, sometimes you can overcome it. There's a dynamic way to approach it, and it's not fatal. It just changed your initial reaction to it.
Yeah.
Other times it is fatal, and you get in front of that. And that's why I think, any attorney who's doing a due diligence at the front end is doing their client a huge service, because they're understanding the terrain as opposed to just launching a war. And I've seen that before. Attorneys will just jump into a case, fire off demand letters or file a lawsuit without really studying what's at play.
Yeah.
What documents do you have? What documents don't you have?
Sure.
Where are we shored up? Where's the exposure? Once you understand the terrain, you have much better footing to launch an attack. So
that's really interesting insight I've never really considered. Okay, couple more. What can I expect in a consultation? We went over a lot of that.
I'm pretty sure I just said.
Yeah. Just an analysis of the terrain. You look at it, looking at the.
So it's the analysis. You're really looking for what are the viable causes of action. That's an elevated way of looking at a dispute.
Yep.
Then it is analyzing what are the methodologies to enforce, whether it's ADR, whether it's litigation, whether it's a demand letter. looking at the economics
Yeah.
of what it might cost. But ultimately, in my mind, a good consultation ends with options, pros and cons of those options, and really leaving it up to the homeowner to make a business decision.
Do you ever send a homeowner on their way and just say, hey, there's a few cards that you can play on your own?
Oh yeah, self-help. Internally, we call it a roadmap because what we've done is we've built a roadmap for the client to take. I shouldn't say client. I should say potential client,
Yes.
someone that we consulted with.
Yeah.
The homeowner, we say, try this first. Run this play.
Yeah.
And sometimes they do it very efficiently, which in my book is a win.
Yeah.
If you don't have to hire a lawyer, that's awesome.
Yeah.
But there are times where they say, "Hey, we tried this, it didn't work. We want to retain," and then we go at it.
Yeah.
So
That's really interesting. I actually like that. Last one. How do I deal with a difficult board?
that's a loaded question right there. How do I deal with a difficult board?
And I think we should say we did an entire series on board member personalities.
We did?
Our episodes are like 40 minutes each of the meddler, the tyrant, the self-dealer. There's so many different personalities in the board that can be problematic, and we did a whole series on how to potentially deal with that personality type.
Yeah, I mean, I think understanding the makeup of the board from a personality perspective is a good first starting point. Who are we dealing with?
Yeah.
And then really, again, sort of going back to that initial strategy of what documents do you have? What evidence do you have? What are your rights? How do the CC&Rs read? What are the governing documents? What are the protections found therein?
Yeah.
And then determining what is the best opening move. Is it just an informal negotiation? Is it a little bit ramped up? Is it an IDR? Do I forget all of that because they're so insane, right? That I just go right to a lawyer. I mean, there's a lot of ways to cut this.
Yeah.
But if you're, kind of in a situation where, it's a difficult board, but there might be an opportunity to work with them.
Yeah.
I don't think that's a bad opening move.
Yeah.
If they're just awful and they're monsters, then maybe you just go straight to an attorney, right?
Yeah.
But it to use sort of a running joke on this show, it depends.
Yeah.
I will say it depends because lawyers say that all the time.
Yeah.
And there's reason for it.
Yeah.
But on that one, it depends on how to deal with it.
So for people that want to know more on that, they should look at our first.
Yeah,
few
I thought it was.
episodes on that.
I think that one's really good.
Yeah, those are fun. And then they can always dive deeper in particularly in the ones where you want to self-help. Here's the steps that you could take. We go into really,
it's a
really
great
deep
resource.
detail where they can take a look at that.
Yeah, I read a comment on the meddler, and I thought it was funny because someone said that it sounded like a Batman villain, and it really does. So, all right.
It. I think we covered 9 and the bonus, so the top 10.
That was 10.
That was
10. Good.
Yeah.
Well, thank you, Marty. I think that was successful.
Thanks for the insight. This was, really revealing to me because I was even kind of putting my hat on as a PC sitting in a console. What would I ask? And a lot of these questions, I had no idea what the answer was. It totally hit me by surprise as well. So I learned something new every time.
Well, thank you for setting this up. I enjoyed it.
Yeah.
And thank you guys for watching. Again, if you like the show, subscribe and also leave comments. We actually read them. So take care, and until next time.